Hey guys, welcome back to the channel again. In today's lecture, we will discuss about the stages of investigation, trial and inquiry while trying or while taking cognizance of any criminal cases. So let's start with our first slide. As we have already discussed about this thing that cognizance under section 190 can be done in three ways, either after submission of police report after lodging an FIR, or by making a complaint before magistrate, or after receiving the information directly before the magistrate. If we are talking about the investigation stage, if any person has lodged FIR under section 190 clause 1, in that situation the process of investigation will start as soon as the FIR has been lodged, and it remain continue till the submission of police report. That means the investigation stage will be considered starting from lodging an FIR to the submission of police report. If we are considering the stage of inquiry under section 190 clause 1, the stage of inquiry will commence as soon as the cognizance has been started by the magistrate, and it continues to the stage of framing of charge. That means everything which includes in between the phase of cognizance to framing of charge will consider to be as a part of inquiry, from starting from cognizance of any case till the framing of charge. While considering the stage of trial under section 190 clause 1, the trial stage would commence as soon as the charges has been framed, and it will remain the same till the pronouncement of judgment. That means everything which comes between the framing of charge and judgment till pronouncement of judgment, all these process will be considered to be as a part of a trial. Now the question arises, what if there is no FIR has been lodged? In that situation, the investigation would commence as soon as the grievances has been told before the police officer, and it will continue to the submission of police report before the magistrate, irrespective of fact whether the FIR has been lodged or not. It will remain to continue till the submission of police report. Similarly, in case after documentation under section 207 and 208 and before framing of charge, the accused get discharged, in that situation as soon as the accused get discharged, the case closes here only. That means this kind of situation or illustration does not include the stage of trial. As we have already discussed that from FIR till police report submission, this would cover under the part of investigation. While talking about from cognizance till the framing of charge, these four will cover under the part of inquiry. And in case after framing of charge till pronouncement of judgment, this would cover under the category of trialing stage. Now the question arises is, what is for that particular left phase, that is between police report and cognizance? This part neither covers under the part of investigation nor in the part of an inquiry. So here we are assuming that, it has been assumed actually, that as soon as the police has been submitted its report before the magistrate, the inquiry stage would commence. So this particular left phase or a gap is deemed to be as a part of inquiry. Now, what's the scenario in complaint cases, that is under section 190 clause second part? As soon as the complaint has been made before the magistrate, the inquiry stage would commence per se, and it will remain till the framing of charge. And after framing of charge, the trial stage would commence. Now the question arises that whether there is no stage of investigation in case the complaint has been made before the magistrate. The answer is maybe, as magistrate is having power under section 202. In by using this power, the magistrate, if considers that the investigation should be done, in that situation the magistrate may order the police officer to do the investigation, either under section 155 clause 2 or under section 156 clause 3, as per the direction given by the magistrate, and the investigation stage would remain till the submission of police report, as in the case of lodging an FIR. Now the information has been received by a magistrate, and as soon as the cognizance has been taken up by the magistrate till the framing of charge, that would only cover under the part of an inquiry, and after framing of charge till the pronouncement of judgment, it would cover as a part of a trial. And in this case too, if the magistrate considers that there should be investigation to be done, in that situation too, the magistrate may order under section 202, as we discussed, to conduct that investigation. Now the question arises whether hearing of a charge is a part of inquiry or a trial. As we all know that as soon as the documentation has been completed, the framing of charge would commence. In that situation, hearing of a charge is either a part of inquiry or a trial. So as we know that thing, that the part of inquiry would remain till the framing of charge. So that's why the hearing of charge, that means what kind of charges would frame against that particular person, would be considered as to be a part of inquiry. Let's discuss the previous things with some illustrations. So firstly, we have that the complaint has been made. So we can say that as soon as the complaint has been made, the stage of inquiry would commence. So there is inquiry here. Then after complaint proceeding, then cognizance. Till cognizance, we can say that there is a part of inquiry. But after cognizance, there is no framing of charge. That means there is no part of trial here. Then directly there is a dismissal. So we can say that there is only inquiry. There is no investigation, as no order has been made by magistrate under section 202, and there is no stage of trial because there is no framing of charge. Another illustration we have that the information has been received and the cognizance has been taken up by the magistrate. That means the part of inquiry has been started and it will continue till the documentation, but there is no framing of charge here. Directly there is a discharge at the stage of hearing of charges. So we can say that there is no investigation, as no order has been made. Similarly, there is no trial because there is no framing of charge, and there is only enquiry because the cognizance has been taken up by the magistrate. Another illustration we have that an FIR has been lodged and the police report has also been submitted. The cognizance has been taken up by the magistrate, then the documentation, then discharge. So in this case, as the FIR has been lodged plus the police report has been submitted, it will include the part of investigation. That means investigation is there. Then after cognizance till discharge, it will include the part of inquiry, but there is no trial. Next illustration we have that FIR has been lodged, police report has been submitted, then the framing of charge is there, and the pronouncement of judgment is also there. So in this case, here all these three stages are there. After FIR lodging and still police report submission, investigation we can say, and till the framing of charge we can say inquiry is there, and from framing of charge till judgment trial is there. So this is an example in which all these three stages are included. Now the question arises whether any inquiry would be possible before submission of police report. The answer is yes. The magistrate is having power under section 159 of CRPC that if the magistrate considers in that situation, he may order to do a preliminary inquiry before the submission of police report, and this preliminary inquiry would be a part of investigation. It would not consider to be as a part of inquiry. So this is all about today's lecture. Rest of the things we will discuss in upcoming video lecture. Thanks for watching, and please do not forget to subscribe my channel for more new videos. Thank you.